Hello and welcome. Today we're jumping right into a huge concept in criminal law, Actus Reus. Now, I know it sounds a little intimidating, but it's really just the legal term for the guilty act, the physical part of a crime.
So, let's start with a real head-scratcher. Can you actually be found guilty of a crime you never, did? It sounds impossible, doesn't it? But as we're about to find out, the answer isn't so simple.
Okay, so to get our heads around this, you have to think about the DNA of a crime. Every single criminal offense is basically built from two core parts. There's the act itself, and then there's the state of mind behind that act. You need both for a crime to exist.
And this idea is nothing new. It all comes from this ancient Latin maxim. Don't worry, I'll translate. It says, actus non facit reum, nisi mens sit rea. All that means is an act doesn't make a person guilty unless their mind is also guilty. So a physical action only turns into a crime when there's a guilty intention driving it.
So, the law splits these two things up. On one side, you have the Actus Reus, the guilty act. This is the external, physical part, the thing you can actually see happen. And on the other side, you've got the mens rea, the guilty mind. That's the internal stuff, the intention, the motive. In this explainer, we are going to focus completely on that first part, the Actus Reus. So who has to prove all this? Well, a huge case, Wilmington v. DPP, gave us what's called the golden thread of criminal law. And what this principle says is that it's the prosecution's job and their job alone to prove both the guilty act and the guilty mind. And they have to prove it beyond a reasonable doubt. If they can't prove both, that golden thread snaps and the whole case just falls apart.
All right, let's dive into the single most important rule for a guilty act. And it's this: the act has to be voluntary. That means the person had to be in conscious control of their actions.
Lord Denning summed this up perfectly in the case of Bratty. As he put it, no act is punishable if it is done involuntarily. Think about something like a muscle spasm, a reflex, or something you do while you're passed out. The law says you can't be held responsible for those things because you didn't choose to do them.
Here's a super simple example to make it stick. Imagine a driver is just going down the road, and they suddenly faint. Their car then causes a huge crash. Now, technically, their body and their car caused the accident, right? But because they were unconscious, the act of driving was totally involuntary, so it's not considered a criminal act.
But this brings us right back to our big question. Can you be found guilty without actually performing a voluntary act? And the answer is, weirdly enough, yes. The law has three really important exceptions to this voluntary act rule.
These are the three main ways you can commit an actus reus without doing what we'd normally call an act. You have situational crimes, crimes of possession, and crimes of omission. Let's break each of these down.
First up, situational crimes. This is when just being in a particular situation or state of affairs is the crime itself. The case of R.V. Larsonnière is a really famous and honestly a pretty harsh example of this. You had a French woman who was forcibly taken from Ireland and deported to the UK against her will. The second she landed, she was arrested for being illegally present in the country. Now, she had absolutely no choice in being there, but the court said it didn't matter. Just being found in that situation was enough.
Next, we have crimes of possession. This is pretty straightforward. It's a crime just to have control over something that's illegal. In the case of R.V. Warner, a guy was given a box. He claimed he thought it just had perfume inside, but it was actually full of illegal drugs. The court decided that even if he didn't know exactly what was in it, the simple act of choosing to possess the box was enough. His ignorance about the contents didn't get him off the hook.
And our final exception, crimes of omission. This is where the crime isn't what you did, but what you failed to do. This only happens when you have a legal duty to act, but you choose not to. The textbook case here is R.V. Miller. A man fell asleep with a lit cigarette and his mattress caught on fire. But instead of putting it out or calling for help, he just got up, moved to another room, and went back to sleep. The court said that because he created the dangerous situation, he had a duty to try and fix it. His failure to act was the crime.
Okay, so we've got the act. But for certain types of offenses called result crimes, think things like murder, where a specific outcome has to happen, the prosecution has to prove one more critical thing. They have to prove the chain of causation.
Now, causation is actually a two-part test. You have to prove both. First, there's factual causation. This uses what's called the but-for test. You just ask the question, but for the defendant's action, would this harm have happened anyway? Then there's legal causation. This asks if the defendant's act was a really significant or substantial reason for the final outcome.
Let's see this but-for test in action.
because it's easier with examples. In R.V. White, a man poisoned his mother's drink, but she had a heart attack and died before she ever drank it. So, but for his action, would she have died? Yes, she would have. So, he wasn't the factual cause of her death. Now, compare that to R.V. Dyson. A man beat his child who already had meningitis. The injuries from the beating made the child die sooner than they would have otherwise. But for the beating, would the child have died at that exact moment? No. So in that case, there is factual causation.
Now for the second part, legal causation. The defendant's action has to be a substantial and operating cause of what happened. The case of R.V. Pagett is a really intense example. A guy used his girlfriend as a human shield while he was in a shootout with police. The police fired back, and sadly, she was killed. Even though it was a police bullet that was the final cause, the court said that his act of putting her in that terrible position was a substantial cause of her death, so he was held liable.
This leads us to a really interesting legal idea called the eggshell skull rule. Basically, it means you have to take your victim as you find them. So if your victim has some kind of unusual weakness, maybe they have a skull that's as fragile as an eggshell, or maybe, like in the case of R.V. Blue, they have a religious belief that stops them from accepting a life-saving blood transfusion, you can't use that as an excuse. You're responsible for all the harm that follows, no matter what their pre-existing condition was.
So, can this chain of causation ever be broken? Can something happen that cuts the link between your action and the final result, clearing you of responsibility? Well, yes, it can. The legal term for this is a novus actus interveniens, which just means a new intervening act. So, what kind of new act can break the chain? Well, if the victim's reaction is something predictable, like in R.V. Roberts, where someone jumped from a moving car to get away from an attacker, the chain is not broken. But if the victim makes their own free voluntary choice, like in R.V. Kennedy, where they chose to self-inject drugs that the defendant supplied, then the chain is broken. The same kind of logic applies to medical treatment. Normal or even poor medical care won't break the chain. But if the treatment is grossly negligent, as it was in R.V. Jordan, meaning it was so bad it becomes the new cause of death, then the original defendant might be off the hook.
So let's quickly wrap up with the main takeaways. First, Actus Reus is the physical part of a crime. Second, it has to be voluntary, but you've got to remember those big exceptions: situations, possession, and omissions. Third, for result crimes, the act must be both the factual and the legal cause of the harm. And finally, that chain of causation can sometimes be snapped by a new intervening act. And that brings us right back to where we started. This quote sums it all up perfectly. The law does not punish evil thoughts, only guilty acts backed by guilty minds. At the end of the day, it's that unbreakable link between the action and the intention that sits at the very heart of criminal justice. Thanks for watching.